Hi everyone, welcome to NCA MEDC. This is Vidya Putran, and in today's lecture, I'm going to discuss about the changes that has been made to criminal law syllabus in June 2024. So they have added a few case laws and removed a few case laws. So now, what does it mean for the students who have prepared with the materials little earlier than these changes? My honest opinion is that try not to use the case laws and the ratios of those case laws which they have removed. Okay, so just make sure that you are deleting or crossing off such case laws that have been removed from the syllabus. Okay, try not to refer them in your exam answers. And whatever cases that has been added, to which portion it has been added, just make a note of it and study those case laws and just see why that case law is added under this particular topic. See the connection. See any case law that will be talking about many feature. It will feature a lot of things, right? A case will consist of charter questions. We are talking about criminal law, so certainly some offenses, right? And punishment, sanctions. If you see, it will one particular criminal law case will be covering entire criminal law syllabus, right? But why we have to focus on this particular case law in this chapter? For example, here they talk about actus reus. Under actus reus chapter 5, under causation, they have added this strategy case law. So just look at it and find why it is important to understand the concept of causation. Okay, so let's begin. The first change that I observed was done to the chapter number 4, that is interpreting criminal provisions. Now, in the interpretation, they have added a older case law. It's not 2024 or 2023 case law. It's a older case law of 1987, R versus Pare. Okay, and this case is interesting. If you, I strongly suggest that you go to Candly and download the actual judgment of this particular case and study it fully. But for those who are preparing, in the month of preparing to appear in the month of August for the NCA exam, I understand that you don't have that much of time to do your detailed study. So here I am with the summary of the case law and how much you should actually know and how you can still manage to, refer these cases in the exam in the way that they intended to. So now let's see our first case law, R versus Pare, 1987. The accused in this particular case murdered a young boy 2 minutes after indecently assaulting. The killing was motivated by fear that the child would tell his mother about the incident. At trial, the jury found the accused guilty of first degree murder pursuant to section 214, clause 5, clause B of the Criminal Code. At the time of the offense, it's 1987. So, at the time of the offense, section 214, clause B, clause 5, clause B, provided that murder is first degree murder in respect of a person when the death is caused by that person while committing an offense under section 156, like some section, but here it was indecent assault on male. Okay, so while committing, this word has been the center point here. Like they were trying to interpret the section, the provision 214, clause 5, clause B, especially the word that is while committing, because if they had to convict him for first degree murder, they'll have to basically interpret this particular section where it says that whether it is murdering somebody, that is causing death of somebody while committing an offense under certain section. Now, what did the court say? The Court of Appeal dismissed the accused's appeal but substituted a verdict of second-degree murder for the jury's verdict of first-degree murder. So jury gave the verdict of first-degree murder, but the Court of Appeal dismissed that and gave a substitute of verdict of second-degree murder. This appeal is to determine whether the accused murdered the child while committing. Later on, this went on appeal. That's why this case is, gone to Supreme Court later on appeal. And then that appeal was for the purpose of determining whether the accused murdered the child while committing the indecent assault or not. Now, what the court held? Court actually held that the appeal should be allowed. So first of all, the appeal was allowed. Then how did they interpret? So this is why it is important for this particular topic, right? So in this chapter, we are basically interpreting the criminal provisions. So how to interpret? So other material that is there in your notes, along with that, just refer to this case law in addition. So this paragraph is important for you to use or understand and apply the same in your exam. So here the court observed that the words while committing. So here while committing in section 214 clause 5 do not require the murder and the underlying offense to take place simultaneously. So while committing does not mean it has to take place. It need not take place simultaneously. Okay, do not require the murder and underlying offense to take place simultaneously, where the act causing death and the acts constituting the indecent assault all form part of one continuous sequence of events forming a single transaction. The death is caused while committing an offense for the purpose of section 240 clause 5. So here, when they were interpreting this particular, first degree murder in the Supreme Court, finally, when they were interpreting this section for the purpose of convicting him for first degree murder, they had to interpret the word while committing in order to see whether it's the same transaction, whether it is, happening simultaneously. So they said that it need not require to happen simultaneously. So one after the other, that is a continuous sequence. So if you see the facts, it says that after 2 minutes after the assault, he, choked him to death or something, right? So he killed him just after 2 minutes. So even if he gave that 2 minutes gap, we know, right? Like in the court, when two advocates, are arguing, they will finally it comes to what? The word of the law, right? How we are interpreting, how we are giving a very solid argument with respect to whether this applies to our client or not. So here the defendant's advocate might have done a really good job into, going to the words and, trying to say that this is two different acts, okay? And he might have tried to get it, reduced to second degree murder. But finally, what happens? Finally, it's in the hands of the court, how and what they are going to accept as an interpretation. So here, finally, what happened? They accepted that as for the purpose of this particular section, interpretation of this particular section and application of this particular section, they said that this forms as while committing. Okay, so the offenses under section 214 plus 5 all involve the illegal domination of people by other people. Accordingly, it is the continuing illegal domination of the victim which gives the continuity to the sequence of events culminating in the murder and makes it a single transaction. So if the victim is under the dominance of the culprit, okay, he's still holding him, he's still under his confinement, then it has to be a single transaction. Okay, so that's how they interpreted it. The murder represents an exploitation of the position of power created by the underlying crime and knits the two together. The conviction of first degree murder should be restored. So earlier conviction that happened at the trial, so same thing was restored by the Supreme Court. So this is why this particular case law has been added to understand to have a deeper understanding of interpretation of criminal code provisions and how it is seen by the court. Now moving on to the next change that happened in your syllabus is done to chapter 5, actus reus. Actus reus is a very important topic, and under that we have point number 4, that is causation. So under causation, we see that they have added a case law, R versus strategy. Now this case law again comes up in another topic, but here let us just understand what does it mean to its importance on causation. So facts of the case goes as follows. Taylor Gordon's strategy was a part of a group that entered an apartment and assaulted several occupants. One occupant, Mr. Tonk, died from a single stab wound. Strategy was charged with manslaughter. The trial judge acquitted him, reasoning that the single stab wound could have been inflicted by one principal offender, and the Crown had not proven beyond reasonable doubt that Strathspey inflicted that stab wound. So it was, multiple people were there, like offenders were there, right? So as a part of a group, he entered that particular apartment and started assaulting people. So here the Crown was not able to prove, had not proven beyond reasonable doubt. We know that actus reus and mens rea has to be proven beyond reasonable doubt, right? R versus minus. Remember? So here, beyond reasonable doubt, he did not prove that who did it, right? Who is the person who did that particular, stabbing of this Mr. Tonk. Now, ratio of this particular case is the Supreme Court of Canada focused on co-principal liability under section 21(1)(a) and 21(1)(c) of the Criminal Code. So if you remember, 21 is talking about parties to the offense. So joint or co-principal liability applies when two or more individuals act together with the intention to commit an offense, are present during the commission of the offense and contribute to its commission. For manslaughter, in the context of a group assault, the focus should be on whether the accused person's actions were a significant contributing cause of death, not on identifying the specific individual who inflicted that fatal wound. So it's not basically like me taking the knife and actually stabbing the person. If I'm there, like holding their hands or like holding them hostage, I'm participating in that particular crime, I'm contributing it enough to cause that particular crime, then that will also be considered under the actus reus. So now finally, that is a here important point. Okay, so in your exam, if there is a multiple party that is committing an offense in a group, 2-3 people, friends committing an offense, and one person did this and another person is holding them hostage and other person who was holding their hands. So like this scenario will come in your exam. So that time you have to apply this particular case and say that here in order to prove, okay, let us name them Mr. A, B, C. Okay, Mr. A, B and C, 3 men. They are committing a sexual assault on Miss D. Okay, so now let us say that Mr. A is the actual person who sexually assaulted Miss D, but B and C was just standing there. B was in the room. He was holding a knife at Miss D and, kind of making her not shout. Okay, just holding the knife and just threatening her. And Mr. C was outside the door, just guarding them. Okay, so that nobody comes in. Okay, so here, What do you think? Whether only Mr. A is doing the act, actus reus, or under causation should we also, interpret here that Mr. B and C also are liable. Okay, so here when we are proving the actus reus, uh, there are five points, right? After causation, we also have omission. So to do or not to do, both are considered as an act, right? So whether they are doing the guilty act themselves, or whether they are becoming a reason or contributing, or they are aiding that particular act. So all these points are to be looked at in this particular case law. So the decision of this case law, the Alberta Court of Appeal found that the trial judge erred in failing to assess Strathady's culpability as a co-principal to manslaughter, given his participation in the group assault. The Court of Appeal set aside the acquittal and entered a conviction for manslaughter. So earlier there was a acquittal for Strathedy, but when it went on to Alberta, the Alberta Court of Appeal, it was set aside and he was convicted for manslaughter. The Supreme Court of Canada upheld the Alberta Court of Appeal's decision, affirming that the Strathady's conviction for manslaughter. The Supreme Court of Canada agreed there was no basis to view the stabbing of Mr. Tong as a distinct act outside the scope of the group attack. The actions of all assailants in the group assault can constitute a significant contributing cause to all injuries sustained, including death. So it's not that, okay, I thought we were just going there to, threaten them and just, slap them off or something. I was just looking for some kind of, hostage situation, but it ended up in death. So I might argue that I did not have the intention and I did not do that particular act myself. So neither I had the intention nor I did the act. Like that I can argue, but I would definitely fail, because use this as your point in proving that actually the actions of all assailants in a group assault can constitute a significant contributing cause to all injuries sustained, including death. Just apply this particular point in your exam. The case underscores the principle that in group assaults, actus reus is not confined to the specific physical act causing harm, like the stabbing of that particular person, like taking the knife and stabbing him, that is the actus reus of that particular crime, right? But here that causing harm, the physical act of causing harm was it was not confined. The actus reus was not confined there. So look outside the scope of that particular act also. Okay. So when there is a group, just see that whether the principal offender only is guilty under that particular crime for doing that particular act, or even if you prove other people had the intention but they did not do the act, so Crown has to prove both actus reus and mens rea, no? So here apply this case law. It's a very good case law. Apply this case law. Just say that to say that all the assailants were there in that particular area, or in that particular act, like as a group they did that, no? So in that assault, whoever took part, they are all liable for that particular actus reus, and they did that. Instead, it includes the collective actions of all participants that contribute to that crime. It illustrates that in cases of joint or co-principal liability, so you have to remember to apply this when there is more than one offenders. Okay, joint or co-principal liability. The focus is on whether the accused action were a significant contributing cause to the offense, rather than identifying the exact physical act that led to the outcome. This case helps clarify that the actus reus for manslaughter in group settings include the combined effect of all participants' actions, emphasizing the broad application of the concept of causation in criminal law. So here, this paragraph you can use in your answer writing in the analysis part while you're making an argument, making a statement, application of this particular case law into that particular facts. While connecting, you can use these wordings. So these are general words. So yeah, that's about R versus strategy coming under actus reus causation. Next, they had added this particular small para into the syllabus under chapter 6, subjective menstruia with objective feature under the B part. What did they add? Along with whatever paragraph was already there, they kept the same. Along with that, they added this paragraph to say that similarly, an accused can be found guilty of sexual assault if they intend to touch another in a way that objectively is sexual assault, even if they do not personally believe that the contact is sexual in nature. This we have already studied in our classes, and we studied under subjective menstruia with objective features under case laws. But they felt the need to add this particular line in the syllabus because they are hinting you to the students preparing that this is important. So whichever case law gave this particular ratio in your syllabus, just mark it. And in case if your exam had a question on sexual assault, where the defendant might be saying that accused person might be arguing that I touched her arm, I did not consider that touching on the shoulder was okay, touched her shoulder, I did not consider the touching of shoulder constitutes as an assault, or like it was not sexual in nature according to the offender. But when we look at objectively, objectively, if it was touched with the sensual, in the appropriate way, it also depends on, we have seen in the classes that it also depends on what they were talking, what was the situation, and what led to this particular touch. So it's not always that the offender did wrong, but it also depends on what was happening around it. And this point is basically hinting that when we talk about menstruia, the mental element, it's negating that it's not just what he thinks, it also what a reasonable person in that particular situation should be thinking. Okay, so objective features, subjective menstruia with objective features, this paragraph they have added. Then comes to regulatory offenses. In regulatory offenses, this particular case law has been removed. So from your notes, you can cross this particular case law and do not refer this particular case in the upcoming exam. Next, chapter number 9, aiding and abetting. Again, R versus strategy here was added because we know it was talking about the co-principal liability where there is like more than one person, right? So co-principal liability. So why this case law is added again here? We understand that section 21 comes, then it also has to come here under aiding and abetting. So we know the facts. Let us move to the importance. So first, it was giving clarification of co-principal liability, that whether the person who actually commits the offense actually committing the actus reus of that particular crime, which is given under your criminal code, only that person is guilty, or even the assailants are also guilty of that particular actus reus. So that we understood. Secondly, the application of 21(1)(a) and C. This also we have discussed. Then regarding focus on significant contributing costs. As we discussed, the decision reinforces that the assessing liability for group crimes, the focus should be on whether an accused person's actions were significant contributing cause to the harm, rather than pinpointing the specific act of the injury. So next, what else? The rejection of narrow interpretations. the Supreme Court of Canada rejected any narrow interpretations that might exclude participants who did not directly cause the harm. This prevents legal loopholes where those who contribute to a crime but not physically execute the harmful act might otherwise escape liability. So, it's also rejecting the narrow interpretation. Next, reinforcement of joint liability principles. Strategy reinforces the principle of joint liability in criminal law, ensuring that all participants in a criminal enterprise can be held accountable for the actions of others in the group as long as their involvement contributes significantly to the crime. In summary, Arvata strategy is a crucial for understanding aiding and abetting, as it clarifies that all participants in a group crime can be held liable if their collective actions contribute to the offense. It supports a broad application of criminal liability in a group setting and ensures that aiding and abetting encompasses significant contributors to the criminal outcome. Okay, now next two cases that has been removed under Chapter 17 are versus Cormier, which in my opinion was a good case. It gave those three points, the reasonable belief and all those points with respect to defense of person, right? Self-defense concept. R versus Cormier was a good case. I actually used this in the exam, I remember. So, but nonetheless, they have removed it. So I would suggest students to not refer to this case in your exams. Okay. But other than that case, we have R versus Lavallee and R versus Kill. Two cases are more than sufficient. R versus Lavallee being little older case that the battered woman syndrome case, right? So that one, and R versus Kill regarding the self-defense shooting of a person. So that is 2021 case law. So that both cases are sufficient to understand and establish the defense of person in your exams whenever you're raising the defense. So they have removed this particular case. Next removal was done under the chapter of provocation, chapter 20, provocation, R versus Land, 2019. That case was removed. So just cross that from your notes. But they also added R versus Brad. This is the recent case that the latest case that has been added. Okay, so 2024 case law of R versus Brad. So here, let us call them Chain Brar was convicted of first degree murder for the death of his wife. Okay, Gurpreet Brar. At trial, Brar admitted to killing of his wife, but contended that he should only be convicted of manslaughter. So he admitted that yes, he killed, but he was claiming for manslaughter, not for the first degree murder. Okay, so he wanted it to be reduced to manslaughter, and we know that can be done by claiming the defense of provocation, right? And we also know that provocation is a partial defense, and it's not gonna be the complete defense. So here, what happened? He argued that either the Crown had not proven the requisite mens rea for murder, or that he had been provoked within the meaning of section 232 of the Criminal Code, which would reduce the charge to manslaughter. Brar raised several grounds of appeal, including challenging the constitutionality of this particular section itself, the admissibility of certain evidence, and trial judge's instructions to jury. The appeal was heard alongside other cases arising raising similar constitutional issues. So finally, now what happened here? The Ontario Court of Appeal, so this is Ontario Court of Appeal case, upheld the conviction of first degree murder. The court addressed the constitutional challenge of challenge to section 232 clause 2 and found that it did not warrant overturning the conviction. The court also rejected Brash's argument regarding the admissibility of evidence and the trial judge's jury's instructions. So whatever appeal grounds that he had, all of them were rejected. The appeal for new trial was also denied, affirming the jury's verdict of first degree murder. Now, how would you apply this and why is it important for provocation, right? So we understand the facts, we understand, okay, he was charged and he was trying to raise provocation, claim, and he also said about, constitutionality, he was challenging the constitutionality of the section. So now the ratio and law of this particular case is, this case is significant in understanding the application of provocation as a partial defense under section 232 of the Criminal Code. The Court of Appeal's decision reaffirmed that for provocation to reduce a charge from murder to manslaughter, it must meet the stringent criteria of causing a sudden and extreme loss of self-control. So what needs to happen? They reaffirmed. Reaffirmed means it's already there, it was already established. They did not establish any new thing. Okay, this decision reaffirmed that provocation to reduce charge, when you use provocation as a defense to reduce charge from a murder to manslaughter, what it should meet, what are the stringent criteria? Stringent means strict criteria. Here, it must meet the strict criteria of causing sudden, so criteria of first one, causing sudden and extreme loss of self-control. This is very important. Causing sudden and extreme loss of self-control. That is the stringent criteria that person should meet. Okay. The court emphasized that the provocation must be both significant and immediate to justify the reduction in the charge. So it has to be both significant and immediate to justify the reduction in the charge. Otherwise, the the murder charge will still prevail. Okay, it will not be reduced to manslaughter. The decision also upheld the constitutionality of section 232 clause 2, clarifying. So they upheld the constitutionality. That means this section is not violating the constitution. So it also clarified that the statutory provisions for provocations are consistent with the legal standards. In order to just summarize the importance of this particular case to the concept of provocation, it is important for clarification of the provocation defenses in Canadian criminal law. The case underscores the high threshold required to satisfy successfully invoking the provocation defense, demonstrating that it must lead to an immediate and significant loss of self-control. The ruling reinforces that provocation alone is not sufficient to mitigate a murder charge to manslaughter. The reaction must be proportionate and directly linked to the provocation experienced. So it has to be significant. The two things that they said, like significant and sudden loss of control, right? Immediate and significant loss of self-control. So it cannot be that, okay, somebody said something to me like half an hour ago and just I go out and come back and then commit that particular murder, right? So I had time to cool down. I had that gap and change of scene, and I premeditated. During that time, definitely half an hour is more than enough to premeditate, right? So even if it is a span of 5 minutes, right? Do not think about, okay, it has to be minimum half an hour or something. I was just giving an example, but in your exam, they might create a situation where the person was definitely instigated, but there was a time to cool down. So in our classes also we were discussing about that cool down part, right? So if there is sufficient time to cool down and it is not meeting the strict criteria of immediate and significant loss of control, then it cannot be successful under the defense of provocation for reducing murder charge to manslaughter. So this case provides a valuable insight into the application of provocation in criminal defenses, particularly in how courts evaluate the immediacy and the nature of provocation in determining appropriate charges. So that's how it is important. This case again will be discussed under another concept. Let's see. So before that, next chapter number 21, entrapment. Under entrapment also they added a case law. This case law actually looks like the type of a question once was asked in the NCA exam. So it's good that they gave the added this particular case law for all of us to study. So when a similar question comes, that you have to apply here the Ramilson case law. Okay. So here what happened, R versus Ramilson 2022 case law. So it's entrapment concept we know, right? Like it's basically the defense claiming that the police actually trapped me into it. So we know the elements that we need to prove under the chapter. We have discussed this. Now, just discussing this case law, let's see the facts. In Project Raphael, I think it's spelled Raphael. Let's go with the project. Okay. So in this project, an undercover operation conducted by the York Regional Police from 2014 to 2017. 14, 15, 16, 17. Okay, in this particular span of years, police posted ads on the escort section of backpage.com to catch individuals engaging in child luring. These ads were designed to solicit responses from individuals seeking sexual services, which were then followed up with text messages from undercover officers posing as minors. Okay. So when individuals arrived at a designated hotel room, they were arrested. Jason Ramilson responded to such an ad after engaging in text messages with an undercover officer posing as a 14-year-old, he was arrested at the hotel room and charged with child luring related offenses, related offenses under sections 172.1 clause 1b, 286.1 clause 2 and 172.21b. Okay. Of the criminal code. At trial, Ramilson was convicted on all charges but sought a stay of proceedings claiming entrapment. He argued that the police had acted without reasonable suspicion that he was engaged in criminal activity, that the virtual space they targeted was insufficiently precise. So in entrapment, we had seen, the police can do this, but there has to be sufficient cause, suspicion, reasonable suspicion and all, right? So here they had a very wide range, like it was open to public, right? So they posted this ad on that particular, .com or wherever in that particular backpage.com and they basically arrested everyone who were responding to that particular ad and then engaging in text message, and police was actually undercover as that particular minor and they engaged in the messages. It was a very detailed trap for catching these people, but there was no reasonable suspicion that this guy was already engaged in such criminal activity. So, entrapment could only win when by the defendant when he's claiming it with the proof that there was no reasonable suspicion. So here this defense is claimed for what? For the stay of proceedings. Okay. So finally, here the Supreme Court of Canada dismissed his appeal, upholding his conviction. The court found that the York Region Police investigation was a bona fide inquiry. Okay. The specific virtual space targeted by police, the York Region Escort section of Backpage.com was defined with sufficient precision. The police had reasonable suspicion that criminal activity was occurring in this space based on the nature of the ads and previous investigations. So it was not something that they came up with then and there and they started doing this. It was already happening. So they were able to prove it. So Supreme Court upheld his conviction and dismissed the appeal. So it is very important to prove that the police had the reasonable suspicion. Okay, that you have to underline that and keep in mind. So, ratio and law. The court affirmed that the entrapment involves an abuse of process when the police officer offer opportunities to commit crime without reasonable suspicion of prior criminal activity in a defined place. This case highlighted that for an online investigations, the definition of space must be sufficiently precise. The Supreme Court reinforced that bona fide inquiry. The police must have reasonable suspicion of criminal activity in specific and defined space. Rational connection. The crime offered by the police must be related to and proportionate to the suspected criminal activity in that space. So here in that booking or backpage.com space, it is an online platform, right? So that space was sufficiently precise. Okay, it was not a wider range. It was sufficiently precise, and they had suspicions because of previous investigations and the nature of ads that was happening there. They were sure, and they had that particular bona fide inquiry, and they laid this particular trap to catch the people who were already engaged in this particular activity. So finally, the court ruled that while the online space of Backpage.com is broad, the police's focus on ads emphasizing extreme youth within a specific regional subdirectory met the criteria of a bona fide inquiry. Thus, the police did not commit entrapment by offering opportunities to commit offenses related to child luring in this context. So you can use this as your ratio in your exam. So importance of this particular case to the concept of entrapment, we already know, but this is a general paragraph. The case is significant for the concept of entrapment, especially to the context of virtual investigations. So it's not a physical entrapment that happens, we have a case of that marijuana case, right? And one more case about phone call. So it comes under that. Okay. So it used to be earlier case laws were talking about phone calls. Now it's all online, right? So this case is also important for our application of for today's problems and today's cases, right? So it's about virtual investigations. It underscores the necessity for the police to establish reasonable suspicion of criminal activity in a sufficient, precise online space before conducting undercover operations. The court's decision elaborates on how entrapment principles apply to virtual environments, highlighting the importance of carefully delineating and defining the online space to avoid overreach. This decision ensures that online police investigations adhere to the principles of a bona fide inquiry, balancing the need to combat crime with the protection of individuals from state overreach. Next chapter is police powers. They have added a case law of R versus Bykowitz, 2024 case law. So this is another 2024 case law that we see. Here is R versus Bykowitz. So under police powers, let's see the facts. The case involved a police investigation into a serious criminal activity during which the authorities sought access to the electronic communications and data from suspect Bykowitz. The police obtained a production order to access these emails and other data from his devices. We challenged this order, arguing that it infringed his right to be free from unreasonable search and seizure under Section 8 of the Criminal Canadian Charter of Rights and Freedoms. So it is a case of charter right violation, right? Unreasonable search and seizure under Section 8. So you can mark that. So the decision of this case goes as follows. The Supreme Court of Canada, in majority decision, ruled in favor of Bykowitz, holding that the production order constituted a search under Section 8 of the Charter. The court emphasized that individuals generally have a reasonable expectation of privacy in their electronic communications and data stored on electronic devices. So before it used to be, we had seen cases about the car and whether, car is considered as the personal space or not, whether his house is considered as personal space or not, whether when he is in the park, having his lunch, whether that space is considered as personal space and can he expect privacy over there or not. So we had discussed all this in our lectures. So now this is about, electronic communications and what is stored in his, cloud and like his electronic devices, all those things about the electronic data. So the majority opinion underscored that such privacy rights must be protected through judicial oversight and clear legal standards. So the ratio of this case, the ratio decidenty of this case centers on the following key points. First, reasonable expectation of privacy. In the unreasonable search and seizure, the protection under Section 8, we always look for reasonable expectation of privacy, right? The court held that there is a reasonable expectation of privacy in electronic communications and data stored on devices. This expectation arises from the personal and intimate nature of such information. Second point, search under Section 8. The court concluded that obtaining electronic data through a production order constitutes search under Section 8, thus requiring judicial authorization to ensure that privacy rights are upheld, balancing privacy and investigative needs. While acknowledging the importance of law enforcement's needs, the court stressed that privacy protections must be maintained through appropriate legal safeguards and judicial oversight. So they're basically looking for a balance of privacy and investigative needs. It's always, individuals' interest into versus the public interest, right? So there has to be that balance. The judiciary, the law always will be trying to get that particular balance. The decision highlights the need for careful consideration of privacy interests in the context of digital communications and reinforces the role of judicial oversight in protecting charter rights. And with respect to next change that has happened to the syllabus under chapter 25, that is securing jurisdiction over the accused and interim release. Under this, they had added few chapters, few pages from the textbook. That is the concept of arrest power and rights on arrest. Okay. So here, these two portions already available in our notes, so you don't have to worry. We have already discussed in our lectures. Okay, you can refer to the lecture notes. It's already available. Next, the final chapter. Here they have made few more changes. They have removed one case law, but they have added 1, 2, 3, 4 case laws. Right. So they have added 4 case law and they have removed one. These 4 case laws, in my understanding, they were more or less similar. They were basically, this chapter is basically uh, talking about the concept of sentencing. So here, most of these cases are talking about the mitigating factors. That's what we discussed in our classes. So let us see what does these case law hold. So they have removed 2016 R versus Lloyd um, decision and added these 4 cases. So 2021 case of Nova Scotia Court of Appeal, R versus Anderson. So what happened in this particular case? Anderson was convicted of assault causing bodily harm and breach of probation. The incidents involved Anderson physically attacking the victim during an altercation. The trial judge considered the severity of this assault and Anderson's prior criminal record while imposing the sentence. So we know we have studied the general principles of sentencing chapter where we discussed about what are the things that the sentencing judge has to consider while imposing the sentence. So previous criminal record, important point, and severity of the that particular crime. All those things also will be considered. So what happened in the trial proceedings? Anderson's defense argued that the trial judge did not properly consider mitigating factors such as Anderson's personal history and the nature of provocation leading to the offenses. So while giving sentences, we know we also should consider certain mitigating factors. Okay, not we, the sentencing judge has to consider them. So in your exam, they might, make you a sentencing judge and ask you to provide the sentence, right? So these general principles and these case law will come very handy when you're trying to interpreting that particular factual scenario that they have given in the exam, and you're trying to apply the general principles and get the actual sentence. So here you need to consider the mitigating factors. So in appeal, what happened? The Anderson appealed on the ground that the trial judge had erred in sentencing by not adequately accounting for mitigating factors and by imposing a sentence that was disproportionate to the circumstances. Court's ruling. The Nova Scotia Court of Appeal upheld the conviction but found that the trial judge had erred in the sentencing process. The appellate court found that while the trial judge had applied the correct principles of sentencing, the sentence imposed was too severe when considering the mitigating factors. He had done like correct principles of sentencing, he has applied, but it was considered too severe while considering the mitigating factors. So the ratio of this particular case is sentencing principles. The appeal court emphasized that sentences must reflect the gravity of the offense and the offender's level of culpability while also considering mitigating factors. The appeal court reiterated the need for a balanced approach to sentencing that takes into account the offender's history, personal circumstances, and the context of crime. Mitigating factors. The appellate court found that the trial judge had not given sufficient weight to Anderson's mitigating factors, including his personal history and the circumstances of the offense. The court held that the sentence needed to be adjusted to reflect these factors appropriately. So the result was the Nova Scotia Court of Appeal ordered a reduction in Anderson's sentence, aligning it more closely with the principles of proportionality and fairness. The court aimed to assure that the sentence was just and appropriate given the totality of the circumstance. Okay. So when you see other case laws also, you might find certain similarity in principles that was applied and the ratio. So we'll just read through these cases and try to understand that what are the slight differences in the case laws and what are the similarities. So sometimes if we have more than one case laws, like at least 2 to 3 case laws talking about a similar ratio, you can apply one of these three. You don't have to write all 3 cases in your exam, right? So you can choose one out of these for applying in the case law, or 2 you can apply. It's your choice and depends on the time also that you have during the exam. In R versus Morris 2021 Ontario Court of Appeal case, so one difference we can see, that was Nova Scotia, here it's Ontario. Now let's see what happened in this case. Morris was convicted of aggravated assault and robbery. Okay, there it was the charge of assault causing bodily harm and breach of probation. Those were the charges. So here, aggravated assault and robbery. So try to see, whatever the offense is in your exam, if it is similar one, try to apply that one, and also consider the background, like their grounds also, like what mitigating factors basically they are looking at. So sometimes they will be looking at mitigating factors of their Aboriginal identity. They might be looking for the mitigating factors like the provocation that came up in the previous case law. So here let us see what happened. The offences involved a violent confrontation during which Morris inflicted serious injuries on the victim and stole personal property. Trial proceedings. The trial judge sentenced Morris to a substantial prison term. The judge considered the seriousness of the offences, Morris's criminal record, and other relevant factors. Morris appealed the sentence, arguing that it was excessive and did not adequately account for mitigating factors. The decision appeal. Morris's appeal was based on the claim that the trial judge had imposed a sentence that was disproportionate to the crimes committed and failed to properly consider the mitigating factors such as Morris's personal circumstance and the context of the offences. Court's ruling. Ontario Court of Appeal found that while the trial judge had correctly identified and applied the sentencing principles, the sentence was too harsh given the mitigating circumstances presented by Morris. The appeal court agreed that the sentence did not sufficiently reflect the balance of aggravating and mitigating factors. So the ratio goes, first one, sentencing principles. The appellate court affirmed that sentencing must reflect the gravity of the offense and the offender's degree of culpability, while also taking into account mitigating factors. Proportionality in sentencing is essential, ensuring that the sentence aligns with both the nature of the crime and the offender's personal situation. Mitigating factors. The court emphasized that a trial judge must give appropriate weight to mitigating factors such as the offender's background, personal circumstances, and any relevant context surrounding the offense. In Morris's case, the appellate court found that these factors had not been adequately considered, leading to an excessive sentence. Result. The Ontario Court of Appeal reduced Morris's sentence to a better to better align with the sentencing principles of proportionality and fairness, the court aimed to ensure that the sentence was just and balanced, reflecting both on severity of the offense and mitigating factors involved. So, mitigating factors, like in both the cases, as I said, looking at mitigating factors are very important. Applying the mitigating factors and reducing the sentences in certain situations are also important. Next, 2023 case law of R versus Hills. In May 2014, the accused fired a hunting rifle at a car and a residential home. He pled guilty to multiple charges, including intentionally discharging a firearm into or at a place under Section 244(21)(a) of Criminal Code. At the time, 244.23b imposed a mandatory minimum sentence of, so we have seen this, right? Mandatory minimum sentence of 4 years imprisonment. The accused challenged the mandatory minimum sentence under Section 12 of the Charter, claiming that it was grossly disproportionate and constituted cruel and unusual punishment. So the minimum mandatory sentence was 4 years. It was not 1 year or 6 months or something. It was 4 years imprisonment. So he basically challenged it under Section 12. So you can see the difference between this case and the last two cases. Here the challenge was under Charter, and he was saying that this was about, and also this is about the mandatory minimum sentence. Okay, so always, like, when at least when the syllabus is changed and they are adding more than one cases, at least see what are the difference, and also try to see that what cases already there, with that what is the difference of the newly added cases, what is the X factor that this case is bringing, that the previous cases did not have. Okay, some might be just reaffirming what is already there, some might be taking it to a slightly next level, right? So, but all of these cases, when I look at what are the changes done, it's not major changes in the sense that we are not changing the understanding of a concept, and it is not some amendment to the code itself, like that happened in the previous years. Changes. It was a huge change to Section 33, right? Section 33.1, but here it's not that. Here these are adaptable changes that along with what we've already had, we are supposed to learn these cases and understand the ratios, so that in the similar situations, whenever in the exam such situation comes, we can apply these case laws and showcase that yes, we are basically updated as per your updated syllabus. We have understood and we know what cases not to refer now and what new cases you are supposed to refer. Okay, just looks like they have given more emphasis on the sentencing part, so I would suggest कि आप just थोड़ा ज़्यादा focus करो on the chapter 31st 31. So, lower court decisions. The sentencing judge agreed with the accused, finding the mandatory minimum sentence grossly disproportionate in a hypothetical scenario involving a less severe form of discharge. Example, an air-powered gun that cannot perforate walls. The judge sentenced the accused to 3.5 years. Okay, mandatory minimum sentence was 4 years, and in the lower court, the sentencing judge gave 3.5 years. The Court of Appeal overturned this decision, declaring a mandatory minimum sentence valid and imposing the 4-year minimum. So now, Supreme Court, what happened? Supreme Court decision. So there were two opinions, okay, like we say the majority and the ascending and the descending, right? So here the majority was, the appeal was held, the mandatory minimum sentence under Section 244.23b was found to be grossly disproportionate and infringed Charter Section 12. It was declared of no force or effect, and the 3.5-year sentence imposed by the sentencing judge was reinforced. Okay, so What are the key principles here? Section 12 of the Charter protects individuals from cruel and unusual treatment or punishment. It includes two prongs: punishment that is excessively severe and incompatible with human dignity, punishment that is intrinsically degrading or dehumanizing. Two-stage inquiry for mandatory minimum sentences. This you can apply in your cases with respect to mandatory minimum sentences. If a section that is charged on your on the person on the accused person, that is having the punishment of mandatory minimum sentence in the code, when you're trying to give the sentence to that particular person, then you'll have to refer to this case. Okay, so just see, first stage, determine a fit and proportionate sentence for the actual or hypothetical offender, considering the objectives and principles of sentencing. Stage 2, assess whether the mandatory minimum sentence is grossly disproportionate compared to the fit sentence. So first one, when you're seeing the general principle, also you're covered with the mitigating factors also there only. And stage 2 is to assess whether the mandatory minimum sentence is grossly disproportionate or it is fitting to that particular offense. Then the third point is here reasonable hypotheticals used to test the scope and impact of the mandatory minimum sentence on reasonably foreseeable offender, including variations in age, background, and circumstances. Such hypotheticals are understood. Reasonable hypotheticals are understood in order to see whether it is, disproportionate or proportionate. Analysis components: scope and reach of the offense, examining the range of conduct covered by that particular offense. That is to be understood. What is the range of conduct covered by that particular offense? The effect of the penalty on the offender, evaluating the severity of the impact of the offender, of the impact on the offender. Penalty and its objectives, assessing whether the penalty achieves Parliament sentencing objectives without being excessive. So here about firing at the car and residence, if it did not lead to, for example, like not causing death or something, so hypothetical analysis, then, as a sentencing judge, you have to see this 4-year mandatory minimum sentence, whether it is exaggerating or whether it is excessive. Here it was. That is the reason why they saw this particular 244 and they basically held it as violating section 12 of the charter, section 244.23b. Okay. So the reasoning was the court found that the 4-year mandatory minimum was grossly disproportionate when compared to a fit sentence for a hypothetical scenario involving minimal risk or harm. It was deemed excessively severe, thus falling to respect human dignity and principles of proportionality. But however, as I said, that was a majority opinion. There was also dissenting judge's opinion that was the appeal should be dismissed. The judge here disagreed with the majority's new framework for assessing gross disproportionality and the interpretation of section 244(1)(a). It was argued that the mandatory minimum did not violate section 12 of the charter and was intended to target offenders who consciously jeopardize public safety. So it was a hypothetical situation that, okay, that see here it did not hit a person, but what if it had, right? So it was not, it was that to see that here the offender is he is consciously jeopardizing the public safety. He knows he's a prudent man. He's supposed to not do that, right? In the public, the firing of that gun, he's not supposed to do that in the public place outside the shooting range or like certain areas where it is allowed. So he is consciously jeopardizing the public safety. So here this judge has a dissenting opinion. The case is significant in understanding how mandatory minimum sentence are scrutinized under the Charter to ensure they do not result in grossly disproportionate punishment. So here it is important to see the majority and dissent opinion, because I remember when we were doing the classes also, some of you had a different opinion from, the one person who was making one argument, right? So the difference of opinion comes there. So even in class, I was saying the same thing, right? So even at the court also, there will be majority. Why we call it as majority? Out of 9 C's, eight people agree, one person does not agree, does not make that one person having applied the legal knowledge. He's also a judge, he has also considered everything, right? So it's a difference of opinion. So that's why we have like the whole bench, right? So to have the majority finally give effect to the decision. And as a law student, when we are preparing for NCA exam, we'll all have different opinions and we are open to interpret them. But these case laws gives us guidance into, how wider our interpretation should go, and um, how much hypothetically, or how much we can actually apply these principles or these steps or tests from these case laws and these ratios into the practical cases. Next case law is R versus Hellback, 2023, Supreme Court of Canada. H, 19-year-old Indigenous male, pleaded guilty to robbery with a prohibited firearm under section 3441AI of Criminal Code. The mandatory minimum sentence is 5 years. So here also, this case and the previous case, both talking about mandatory minimum sentence. Okay. And here one change is that the person who is charged is a indigenous male. Okay, Aboriginal person. So this is the different X factor in this particular case law. Now, H argued that this was grossly disproportionate, that 5-year mandatory, minimum sentence, and it is unconstitutional under Section 12 of the Charter. The sentencing judge found this mandatory minimum to be grossly disproportionate and imposed a 2-year sentence. Now let us see what happened. There is another scenario. Z committed a similar robbery with firearm 3441AI with a 4-year mandatory minimum. Okay. Z challenged this minimum order under Section 12, relying on hypothetical scenarios. The judge found that the minimum disproportionate in hypothetical scenarios, but not in Z's case, imposing a 3-year sentence. So there was 4 years, right? Yeah, 4 years, still reduced it to 3 years. Court of Appeal dismissed the appeals on the constitutionality of the mandatory minimums, but adjusted its sentence to 3 years. So from 2 years sentence, H ka sentence, a 19-year-old person, indigenous person, to 3-year sentence. Okay, that was Court of Appeal. Now, what happened at the Supreme Court? In the majority, the mandatory minimum sentence for both under this section and that section are constitutional. So basically, they said that the mandatory minimum sentence is constitutional. For those offenses, it is proportionate. Okay, and the two-stage inquiry for gross proportionality involves. So here the two-stage inquiry, or you can call it as test. Okay, so what is the test? Apply this in your exam. If it comes up, apply this portion in your exam. What is this? What does this say? A fit and proportionate sentence, and second one is gross disproportionality. So same thing we saw here also. Yeah, here, stage 1, stage 2, right? About two-stage inquiry about mandatory minimum sentence. So both the case laws, I think Hillback and the previous one was Hill, is it? Hills, yeah. R versus Hills. So both case laws are giving us this test and seems important. So what happened in now both of their cases? While applying, the both case came to Supreme Court. So what happened? So while applying this two-stage test, in H's case, what happened? Fit sentence. 3 years is appropriate for H, given the seriousness of the offense. Actually, there 5 years mandatory, minimum sentence was there, and the trial judge had given 2 years, but Supreme Court said that 3 years is appropriate, considering all the aggravating and mitigating factors both. Gross disproportionality. The 5 year minimum, though severe, is not grossly disproportionate. Like it is not to the level that it is affecting the charter right. It reflects a high gravity of the offense and Parliament's interest in deterring such conduct. The difference between this minimum and H's personal circumstances does not shock the conscience. Now, what happens these cases? Reasonably foreseeable scenarios. Only two scenarios, one involving an intoxicated indigenous man with a BB gun and another involving a man with a drug addiction and a airsoft pistol, are reasonably foreseeable. In these cases, a 4 year minimum does not shock the conscience, though it may seem severe. So here, what is the final decision given was, these both are constitutional. The mandatory minimum sentences are constitutional, and H got 3 years and Z also got 3 years. Dissenting opinion. However, there was a dissenting opinion, and here H's sentence regarding that, what was the dissenting opinion? A 5 year minimum is grossly disproportionate, violating section 12 of the charter. The sentencing judge's decision for a 2 year term should be upheld, considering H's personal circumstances, including systematic issues and the profound impact of incarceration. Z's sentence, the 4 year mandatory minimum is unconstitutionally broad and grossly disproportionate in some scenarios, capturing for some offenders, particularly when considering youth, substance dependency, and varying circumstances of offense. So certain key points here, indigeneity and personal circumstances. The court emphasized the need to consider an offender's personal and systematic circumstances in sentencing. That is, also coming under mitigating factor, especially for indigenous offenders. Next, Parliament's objectives. When the mandatory minimum sentences are why they have put. The Parliament, while drafting that particular code, the provision, they have put that mandatory minimum for a particular objective. So what is that Parliament's objective, whether it is reasonable or not, that we have to see. So by the Parliament, these the mandatory minimums are justified by the Parliament's goals of denunciation and deterrence despite their harshness. So denunciation and deterrence are two different forms of sanctions, right? So you can check that out. So here these are justified. Reasonably foreseeable. For the mandatory minimums to be deemed grossly disproportionate, scenarios must be reasonably foreseeable and reflect significant variations in offenders' circumstances. So, these 4 case laws that has added to the chapter number 31, General Principles of Sentencing, also are pretty easy and straightforward and understandable. So these are the only changes that has been done to the syllabus in June 2024. And I know there is a lot of worry in the students that what are the changes and how exactly we are going to understand these. And I have compared the previous syllabus that I had already had downloaded, now the updated syllabus, and I had seen the comparison and I came out with these changes. So nothing to worry. It is not, changing your understanding of the criminal law, what you have learned in its principality, but just adding to it and boosting your knowledge and how you can actually apply these case laws into your examination. So yeah, so I have shared this soft copy in our group, so you can refer to that. Let me know if you have any doubt with respect to these changes and in understanding of these case laws. If you print out this 13-page material and attach it along with our study material, it should be sufficient for you to prepare and apply this in your examination. Okay, thank you so much for listening to this lecture, and I'll see you